Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decisions. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's question to the witnesses, your question to the witnesses, and my question to witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider these things as in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness' testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony that you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence. However, you may conclude that a witness deliberately lied about something that is important to how you decided the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You should not decide this case based on which side presented more witnesses. Instead, you should think about what each witness said in each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 19, 2021 within Midland County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. These are the final copy of the written jury instructions. You should first choose a foreperson. Forepersons should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance of being heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decided you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. We're not going to use a sealed envelope, just fold it in half. Possible penalties should not influence your decision. It's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all the reference documents that have been omitted, just ask for them. Counsel, with the exception of the 911 call, is it okay for them to take the exhibits in to look at them?
Yes, Your Honor.
Yes, Your Honor.
Okay, so you'll have them all. If you want to hear the 911 call again, we have to do it in the courtroom. It's the only way that we can make that happen. I am missing the instructions for swearing in Tracy. So the last week instructions had them at the end. I forgot to put these, so if you can find them, Deb. When you go to the jury room, you will be given a written copy. Oh, we just did that. Nope. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you should give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person coming in from the outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards that you use to evaluate the testimony of any other witness. An agent is a person who has been given authority to represent another person or to act on behalf of another person's behalf. The defendant is charged with the crime of assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery on Larissa Ridman. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the other person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Larissa Ridman's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Larissa Ridman or to make Larissa Ridman reasonably fear an immediate battery. As used in these instructions, the words force and violence mean any use of physical force against another person so as to harm or embarrass him or her. For a battery to occur, the touching must have been intended by the defendant, that is, not accidental, and it must have been against Larissa Ridman's will. It does not matter whether the touching caused an injury. An assault does not have to cause an injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. The defendant is charged with the crime of criminal trespass. To convict the defendant of criminal trespass, the prosecution must prove all of the following elements beyond a reasonable doubt. 1. The defendant entered the lands or premises of another after having been forbidden to do so by the owner or the agent of the owner. 2. The defendant lacked lawful authority to enter the lands or premises. 3. That the defendant had been forbidden to enter the land or premises by Larissa Ridman, the agent of the owner or occupants. 4. That Larissa Ridman had lawful authority to bar entry onto the premises. The last page is a list of possible verdicts. There are 2 charges. Each charge has the option of you finding the defendant not guilty, for example, not guilty of assault and battery, or guilty of assault and battery, not guilty of trespass, or guilty of trespass. You should have 2 boxes. It has to be unanimous as a jury. 2 boxes must be checked based upon what you think is the elements. 1 choice for each charge. So assault and battery is a charge, trespass is a charge. So you need a decision on each charge. Ms. Baumann, is there any clarification or anything you wish for me to add or anything regarding the instructions you would like to have corrected?
No, Your Honor.
Mr. Durant.
Just a clarification that there's multiple counts and that finding him guilty or not guilty on one count does not necessitate the finding of guilt or not guilt on the other.
That's correct. Each of those charges, you can make your own determination, but you must make a determination on each one. So, for example, you're not required to find just because one was proven or not proven, that the other one automatically. You could find them opposite. You could find guilty or not guilty of one, guilty or not guilty of the other, find the opposite. But you must make a decision on each charge. Does that satisfy?
Satisfies. Thank you, Your Honor.
Anything, Ms. Baumann, you wish to?
No, Your Honor.
Okay. I'm going to now swear in the bailiff. Let me give you that question. You do solemnly swear or affirm that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them, orally or otherwise, except by order of this court, or to ask them if they've agreed on their verdict, until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God. If you would please follow Ms. Taylor, she'll take you back. Please rise for